Welcome back to the deep dive. We often look at these big regulatory frameworks, but few are as fundamental to, well, your long-term financial health as the one we're tackling today.
That's right.
You've shared the Pension Funds Act of 1956 with us. It's a cornerstone of South African retirement law, all consolidated and updated right through to April 2023.
It really is a fascinating piece of law. You hear 1956 and think, okay, old news. But what the sources show is a law that's been constantly worked on, refined. It's very much a living thing, managing huge amounts of money meant for people's futures.
Exactly. It's really had to adapt.
Yeah.
So our mission today isn't just to, read out sections. We want to give you the background, the key ideas, the why behind the rules governing your retirement savings. We aim to show how this act builds this really strong structure of accountability. It's designed primarily to protect the member.
Precisely. And the core idea, right from day one, was clear. Provide for the, and I'm quoting here, registration, incorporation, regulation, and dissolution of pension funds. It's about taking something that might have been informal and making it a solid, legally recognized financial body.
With proper oversight, too, from the Financial Sector Conduct Authority, or the authority, as the Act often calls it.
Yes, absolutely crucial oversight.
Okay, let's unpack this then. Maybe starting with the basics, the administrative heart of it. How a fund actually gets started and gets its legal status. That's mainly in the first few chapters, isn't it?
It is. It all kicks off with mandatory registration. That's Section 4. If you're an organization planning to offer annuities or lump sums or even one of these specialized beneficiary funds, you absolutely must register before you even think about starting operations.
So oversight from the word go, that's the first layer of protection.
Exactly. No operating under the radar.
And what happens legally the instant that registration goes through? This part is quite neat structurally.
Yes, Section 5. The moment it's registered, the fund becomes a legal person, a body corporate.
Like setting up a company.
Sort of, yes. It gets its own legal identity separate from its managers or its members. And here's the critical bit. All the fund's assets, its rights, its debts, they automatically vest in the registered fund itself.
Meaning if the company sponsoring the fund hits financial trouble, the pension money is safe. Completely separate.
That's the intention. The automatic vesting means those assets belong legally to the fund entity, not the employer, not the trustees personally. You don't need any formal transfer document like a cession.
Right.
The law just makes it happen instantly upon registration. It cuts through potential legal tangles to guarantee that separation. The assets belong to the fund. Full stop.
And the Act is specific about handling the actual money too, isn't it? Keeping it separate.
Section 5, subsection 2. The assets have to be kept by the fund. They can be held, by approved places like banks, insurers, or other authorized financial institutions, but they are the fund's property.
Okay, so we've established the fund. Now, who's in charge? Governance.
This is where we see some really significant changes over the years, pushing for more member control. Every single fund has to have a board, at least 4 members.
And the key protection.
Section 7A lays it out. At least 50% of that board must be elected directly by the fund's members.
That 50% rule seems like a big deal, but let me just play devil's advocate here for a second.
Go ahead.
If the employer appoints the other half, and often the principal officer too, is 50% always enough clout to really challenge decisions, especially with complex financial stuff?
That's a fair point, and that tension can definitely exist. But the law tries to address it with very clear fiduciary duties, Sections 7C and 7D.
Okay.
They state the board's main job is to direct, control, and oversee the fund, and their core obligation. It's a fiduciary duty owed first and foremost to the members and beneficiaries.
Not to the employer.
Not primarily, no. Their duty demands they ensure the fund is financially solid, managed responsibly, and that they act impartially and in good faith towards the members. Legally, even the employer's appointees have to put member interests first.
That legal duty acting for the member, that's the real safeguard then. And this accountability goes beyond the board to the person running the day-to-day operations, the principal officer or PO.
Correct. The PO has to be resident in South Africa. And the authority, the regulator, they have teeth here too. They can actually object if they don't think a nominated PO is fit and proper.
Fit and proper meaning?
Well, the criteria are pretty strict under Section 8, subsection 5. Things like basic honesty, diligence, competence. And critically, no convictions for things like theft, fraud, forgery, or anything involving dishonesty.
So the regulator acts as a gatekeeper for that key role.
Yes, ensuring someone trustworthy is at the helm administratively.
Okay, let's switch gears slightly. We've got the structure, the managers. Now, how does the money actually get into the fund reliably? This brings us to Section 13A, which I know tackled a massive historical problem.
Oh, absolutely. This section is crucial and heavily enforced. It was a direct response to situations where employers were deducting contributions from salaries, but then just sitting on the money.
Using it as short-term cash flow.
Exactly. Using employee contributions as unauthorized working capital, sometimes for weeks, even months. That created huge risks for members.
So what's the rule now? The hard deadline.
It's tight. Section 13A, subsection 3. The employer has to pay both the deductions taken from members' pay and the employer's own contribution into the fund's actual bank account within 7 days after the end of the month the money relates to.
Just 7 days. That doesn't leave much wiggle room.
None at all. It's designed specifically to stop that money lingering on the employer's books.
And if they're late, what's the immediate consequence?
Interest. They have to pay interest at a prescribed rate starting from day 8. But the really big stick, the one that should get every company director's attention, is the personal liability clause. Section 13A, subsection 8.
Okay, spell that out. Who carries the can if the company doesn't pay?
The directors of the company, or if it's a closed corporation, the members who are regularly involved in the money side of things, they can be held personally liable for those unpaid contributions.
Wow.
Yeah. The usual protection of the company structure, the corporate veil, it gets pierced specifically for this. It's a very strong push for executives to make sure those payments happen on time.
Okay, so assuming the money's flowing in correctly, let's look at bigger changes and the fund's financial state. Chapter 4 stuff, mergers, benefits, and that really complex area, actuarial surplus.
Right. First, amalgamations or transfers, meaning when funds merge or parts move between them. Section 14 governs this, and it's tightly controlled. You need the registrar's approval.
And they won't just rubber stamp it.
No way. The registrar has to be convinced the whole plan is reasonable and equitable, and crucially, that it gives full recognition to members' existing rights and what the Act calls their reasonable benefit expectations.
Which ties into minimum benefits, right? Section 14A. What's the baseline guarantee if you leave a fund?
The Act sets a floor. It mandates a minimum individual reserve. Now, the exact calculation can get technical depending on if it's an old-style defined benefit fund or a modern defined contribution one.
Where it's basically your pot of money plus investment gref.
Largely, yes, plus a share of any relevant surplus. But the core principle is, whatever the fund rules say, your payout when you leave can't drop below this legally defined minimum. And there's more. Section 14B deals with pensions already being paid.
Protecting pensioners, too.
Yes, it mandates minimum pension increases. The board has to consider increases at least once every 3 years, aiming to protect the buying power of those pensions against inflation. So it protects the capital and tries to protect its value over time.
Okay, now for the big one. The issue that's probably filled courtrooms for years. Actuarial surplus. Sections 15A through 15K. Can you break down what surplus actually is for someone listening?
Sure. In simple terms, it's when a fund has more money, more assets than the actuaries calculate. It strictly needs to cover all its promises, all the future pensions and benefits it has to pay out.
So extra money.
Extra money. And the massive fight was always about who owned that extra cushion. The employer. The members.
And the Act now gives a very clear answer.
Crystal clear. Section 15A, subsection 1, all actuarial surplus in the fund belongs to the fund. Full stop. Then it has to be divided up, apportioned, into specific accounts, usually a member surplus account and an employer surplus account.
And the employer can only touch their allocated account. They can't just dip into the main fund assets.
Absolutely not. Section 15E is explicit. The only assets an employer can potentially access are any credit balances sitting specifically in that employer surplus account. It's ring-fenced.
And there are rules about past misuse, too.
Yes, Section 15B forces the board to look back before these rules came in and investigate any improper utilization of surplus by the employer. If they find the employer basically owes the fund money from past actions, that debt has to be repaid.
Okay, this brings us to maybe the most interesting and potentially controversial part of the surplus rules, Section 15J, the jobs for pension fund money idea. Using surplus for something completely unrelated to retirement.
It's definitely a point of tension written right into the Act. It tries to balance long-term retirement security against, well, immediate economic crises. Section 15J allows an employer to apply to the regulator to use cash from their allocated employer surplus account specifically to prevent retrenchments, to save jobs.
It sounds like it would need incredibly strict conditions.
They are extremely high. First, the employer has to prove that major retrenchments, the Act defines this, usually impacting more than 10% of the current employees who are fund members, are genuinely unavoidable otherwise.
Okay, necessity. What else?
Second, and this is the really massive hurdle, they need written approval from at least 75% of the currently employed members of the fund.
75%. That's a huge majority.
It is. It ensures that the people whose potential future surplus is being used for job security today have overwhelmingly consented to it. It shows just how protective the default stance of the Act is towards the retirement promise.
Okay, moving away from surplus, let's talk about general investment roles. Section 19 puts limits on funds investing too heavily in the employer itself, doesn't it?
Yes, that's a vital diversification rule. Generally, a fund can't invest more than 5% of its total assets in the business of the participating employer or lend money to them beyond that limit.
Why?
To stop the pension fund's fate being too closely tied to the sponsoring company's success or failure, you don't want all your retirement eggs in one corporate basket.
Makes sense. Can that limit be increased?
It can go up to 10%, but only under strict conditions, usually requiring the board to certify that the members themselves support taking on that slightly higher risk concentration.
And what about a common benefit loans for housing? Does the Act regulate those too?
It does. Under Section 19, subsection 5, funds can offer loans or provide guarantees for members to buy, build, or fix up their homes. But the security has to be solid.
Yeah.
It generally needs to be secured by a first mortgage bond over the property itself or by a pledge against the member's own withdrawal benefit in the fund. And there are caps.
Limits on how much?
Yes. Usually the loan can't be more than 90% of the property's market value. It can go up to 100%, but only if the employer steps in and provides an additional irrevocable guarantee for the loan.
Okay, so strong protections there too. Finally, let's look at what happens when things go wrong. The ultimate safety net for members. The pension funds adjudicator. Chapter VA. This seems absolutely key for individual members.
It's incredibly important. It's the access to justice mechanism for the ordinary person. The Act sets up the Office of the Pension Funds Adjudicator, the OPFA, as a statutory ombud scheme. Think of it like a dedicated consumer protector for pensions.
Why was it needed? Couldn't people just go to court?
Well, imagine you have a dispute over, say, $20,000 in benefits. Taking the fund or your employer to court over that amount, the legal costs would likely dwarf the potential payout. It just wasn't practical for most people.
So the adjudicator provides a cheaper, faster alternative.
Exactly. Section 30D says the adjudicator must act in a way that's procedurally fair, economical, and quick.
What's the process if you, as a member, think you've been treated unfairly?
First step, Section 30A. You have to complain in writing directly to the fund, or sometimes the employer involved. Give them a chance to sort it out.
How long do they get?
They have 30 days to give you a written reply. If they don't reply within that time, or if you get a reply but you're still not satisfied with their answer,
Then you go to the adjudicator.
then you lodge your complaint formally with the adjudicator's office.
And does the adjudicator just mediate? Or do they have real power? What gives this system teeth?
Oh, it has real teeth. This isn't just mediation. Section 30E is the key part here. It states the adjudicator may make the order which any court of law may make.
So like a judge.
Effectively, yes, within their specific area. It's not just a suggestion. It's an enforceable determination, legally binding on the fund or employer. If the adjudicator finds a mistake was made, benefit miscalculated, claim wrongly denied, poor communication leading to loss, they can order the fund to pay up, recalculate something, fix records, whatever is needed to put things right.
That sounds incredibly powerful for an individual member facing a large institution.
It is. It levels the playing field significantly.
Now, beyond those individual complaints, the main regulator, the authority, still has oversight powers for systemic issues, right?
Yes, that's the broader safety net. If the authority, the FSCA, sees a fund is in deep trouble financially, or maybe it's just completely failing to govern itself properly, maybe they can't even get the required member-elected board members,
And why?
then Section 26 kicks in. The authority can step in. They might direct the fund to change its rules, or in serious cases, they can actually appoint people directly onto the board to try and sort things out.
If it's beyond saving.
If the fund is truly in an unsound financial state and can't be fixed, Section 29 allows the authority to go to court and apply to have the fund officially wound up, liquidated in an orderly way to protect members as much as possible. This really raises an important question, though.
So after all that, what does this all mean for you listening?
Well, the big picture is that the Pension Funds Act of 1956, through all its updates, has created this really quite robust framework built entirely around accountability. You've got member-elected boards holding significant power. You've got the principle that fund assets are sacred, belonging only to the fund. You've got those strict rules forcing employers to pay contributions within 7 days. You have minimum benefit guarantees. You have clear rules on who owns surplus.
And the adjudicator.
And critically, yes, the adjudicator providing that accessible route to justice. The main takeaway for you, whether you're just interested or maybe studying law, is that the system aims to turn your retirement savings into a highly protected legal right, not just a vague promise. It gives you avenues to enforce that right without necessarily needing expensive court battles.
That's a strong summary of the protections. So maybe a final thought for everyone to chew on. We talk about those strict rules around using surpluses, especially that Section 15J, the jobs for pensions provision.
The one needing 75% member buy-in.
Right. How well do you think that specific mechanism actually balances the very real, very immediate pressure of saving jobs in a crisis against the equally important long-term need to protect retirement security?
That tension, that balancing act between today's economy and tomorrow's pensioner, it feels like it's written right into the heart of the act itself. Something to think about.